the constituency and regional collations sheets, the regional and constituency summary sheets, as well as Form 13. We also wanted to find out from them the basis for the different corrections that they had made. So we filed an application, and our council made it very clear that the reason for which we are asking for all these sheets is the fact that, yes, we have, for example, the constituency and regional sheets. However, we need to know the basis for the different figures that the EC keeps coming up with. You recollect that there's a figure of the 9th declaration, which was quoted as the valid votes. There's the alleged correction that was made on the 10th. There's also the figure of 13,121 plus, which they quoted in their paragraph 24 of their answer, which was a sort of acknowledgement of what we were saying in our petition. So they've come up with different figures. We don't know the basis for which they have come up with those figures. And therefore, we needed to see the originals of those documents to be able to make our own assessment before we cross-examine the first respondent's witness. Unfortunately, the Supreme Court did not agree with our request. It refused our application on the grounds that these are documents that are in our custody. But while the Supreme Court has ruled, there's not much we can do, but we disagree with the fact that all these documents are said to be in our custody, and therefore we are not entitled to it. You heard the two witnesses that have testified so far. Both of them, for example, have said the Form 13. They have never seen or signed the Form 13. And that is at least one document that we don't have in our custody, the most important document of all. We've never seen it. Again, we've made it clear that we were not part of whatever discussions happened at the EC when the different corrections were made. And therefore, we need to see the basis for those corrections. Well, we've been denied that opportunity by the court. But that's not the end. We'll still continue with our case. Questions?
Counsel, at the close of proceedings yesterday, Mr. Chikata had indicated that depending on whether this request was granted or not, it may determine the possibility of calling another witness. We saw at the close of proceedings that another request was made about a potential witness. We know we are not supposed to know the specifics of that particular decision, but we just wanted to find out, is it a case that you are going to call another witness, or has that request been granted and you don't have to file a witness statement for another witness to come?
As you saw, I did not enter the room with the counsel and the judges. We are not privy to that discussion, and it's not for public consumption. That's why it was held in camera. You notice that when His Lordship, the Chief Justice, came and adjourned the case, he did not give any details. I do not have the details either.
All right. We know that he who alleges also bears the burden of proof. You have come to court without certain facts that prior to filing the case in court, there were some communications put out there to suggest that you did have all these facts. Indeed, today we get the impression that this application was an afterthought. You were not prepared for it. You had 21 days to have been able to put all these facts together. Why didn't you do that earlier on? Was it an afterthought?
You're entirely wrong. Maybe you misunderstand our case. We have stated clearly what our case is, and it is based on the declaration of the EC. Based on the declaration of the EC, that no candidate got more than 50%. It's based on the fact that there have been so many corrections to that figure, which nobody knows the basis of. And that is why we say that the declaration is null and void. We have come fully prepared for this case. And in any case, the EC is supposed to be an impartial part of this whole election process. What do they have to hide? What prejudice will be occasioned to them if they produce the documents for us to see? None whatsoever. If you conducted your activities as EC chair, fairly, transparently, impartially, why will you not produce the documents for us to see?
I want to also ask about the impact of the application that was denied your side on the case going forward. Are we expecting to see you call another witness, or would say that based on what we have seen so far, the two witnesses you have already called are the witnesses you have to make your case with?
I think you've just asked the same question another guys. You all see what will happen on Friday.
Yeah, I want to find out how strong your case is now, looking at the number of applications dismissed by the court.
We still think we have a very strong case. We are very, very certain about the case we have before the court. Irrespective of the fact that our applications have been refused, we came to court prepared. We are ready to continue with the case, and we will go through with the case till the very end.
The case has been adjourned to Friday. On Friday, are we expected to see your side cross-examining Madam Jean Mensah?
The case has been adjourned to Friday. The Chief Justice did not tell us what is happening on Friday. We'll all see what will happen in court on Friday. Thank you. Chief.
You are for Yabedam was say Yabebo and Nedi C. Ewa court tofa ewutri kasemwa. Ni nyina ne se ene yabaye ye lawyer e de ebisade eto Supreme Court no enim se on share the first respondent the Electoral Commission of Ghana. Na enkrata omugina so e de ebobo aba it declares Omampenye Kufuado now winning the 2020 presidential elections. No, Omon Famra Court na afafa ni nyina atimi ahwehwem ahwese enkrata ni nyina dimu a bibia ededa nakwam. Enti eno ho arguments enenne ye lawyer Chachuchi Kata ya mutibi no. Na asem wo kan ye ne tofa bo mu nyina ne se sa documents aye ka ho asemi se court no anhye Electoral Commission for amoma ma court ama ya anhwehwe mu a enya de a atentene ni betumi aye adwuma na yatumi ehu emmadodo a epiem ewo 2020 presidential elections ni mu na senti okasa ne se yakoto abato baako e bia da yete results for on 7th December 9th December Jean Mensah or returning officer or declare results no the figures be two dra what say or bosso or the total valid votes or the two dra in that declaration, you know, 13,434,574 kwansima adia chen ya na mami asanso asesana no the figures for fraba the room 13,433,573 after the total valid votes in Ukraine, another figure 13,119,460. You be peer court or so. No, I answer the figure for Fraba. So, figure original so they declare Banama Mampenye Kufuado. They say they are 13,121,111. Let's just say, according to lawyer Chachuchi Katano, figures no adoso. Ye name the documents in Krata is the agent so the figures we in our eba. It is a attention in Niaba court, no cranty Niaba court, near Pese Peri your year, Jumadia, and you need the Munos, there's a court on the Beshe easy. Now, modest and crata naba near Yetimi Ashiship. Now, our request is to say you, and Yano Cresse, a Yenea no make his our request, not to say, Yenuanum Ekaye. Or yes, our request no true idea friend of mutual discoveries. as far back as 19th January. Senka we dear, e ma court to crumple mum. Ya ho ye ho no. Mpenyufo so utimu fita tia mu anku. Enti say wonya boni bia dia ma yen hwe wo documents a wugina so dey sa figures ahodo nyina bai. But the nam say EC4 anti asienti enene wode service ade ebeto court no enim. Court no de natemu bai. De omo kan ne say omo ne anya adwen nti enya de omo be hye EC ama omo de sankrata no aba court ama yahwe because sa documents are ye pese EC4 de ba no ye woni nyina emra ne say at every level of the election process and there was say ye be my agents na ehọ ena nidie mu ye ne court no enya adwen esan say we hwe adanse a eda court na nim na bibia chire pefe say documents no bebre wo ha NDC for ye ni bi. For example, document a friend of Form 13 enra yura Dr. Chris White adanse mu ehho ba asem wo be hwe judge ba ko e de sa form ne chire no e sa form no na G-Mensa na Electoral Commission for say omo wi abato ne ho adwuma nyina wiye no omo record ma obi anya ye wo so ma agency nsan ye na wo Dr. Chris White adanse mu te say wo chire mu say samre ni mpo ano mo yesa de na omo as agents no mu ni ho because na G-Mensa adada omo ama omo afiri wo say omo ne the flag bearer of NDC kwa ko din kita ho bi it is our Form 13 no omo ni kosua say enhu bi yamfa ama omo krompo na campus o maka say yen sign na ye reason ni enti omo ni bi and for that matter NDC ni bi enti hot ye ni die mu ye ne court ne nya adwen say documents are ye bisa ye ni nyina ye wo bi because clearly no ye need Form 13 whether duplicate or original ebiem it can be correct to say oh pink sheet polling station mu obi constituency summary sheet mu obi regional coalition sheet mu obi yes but ye nyina ye wo bi ye de ye declaration we on the 9th no eno achi G-Mensa ne nko ne EC4 akwa kwhye kokuom asesa no ensesa omo ye nyina no so no ye gidi se ejina nkrata bi so omo sesa ne we no omo san so akwosesa ne biem omo san so akwosesa ne biem enti enkrata omo gina so de sa different figures na ba ne ye ni bi enti sa wo kasa ye wo documents ni nyina adenti ne ye san so bi sa omo a na ni diemu ye ne wonya adwen because the foundation documents for the different figures they have churned out are not in our possession. It is a Nissan krata na e sidan na wo be hu se we na ye krata papa EC4 UC and we nya papa na de twato wo be kaya Eastern region coalition sheet e ho aba asem coalition sheet na koye mienu ni nyina EC4 de omo sa ahase ba EC4 a kire se ba ko ye papa ba ko nya papa say EC4 emphasize our originals now omo omo declaration and all the corrections now ma e see then na NDC ye which of these two documents the EC used for declaration ye challenge in the for it is not the case say NDC for ye near dance ye bia ne aba court ne ye ba be hweda bi ba ye nyina ya ba court ye no kra ne atentere ne pese ye adwuma na Electoral Commission ni moto ye transparency fairness and integrity. Now no na say why abato bibia da wo fan o mampenye kufu ado awe ne na fe fankrata ugina so de hu so mampenye kufu ado awe ne bra ne nyina ye hwe a wo se me ma wonfa wani kosua mpo nya dan enhwe ti we asem se ba ye beja ya magana fo na mo ankasa mabua ba ye de ye wogidie mapase no kre ohoi eye ba kope aso nyame kokruko itato we no kre wa asem we bia mu no ebepie whether or not this application has been granted or refused enti efie da court the share say am right beba so ye hwe ni mu say sanso ne mu be hia bi meda mu nyina mase say mo bye thank you akade nyina unu mo dia kwa let's pass just
So, colleagues, shall we go? Shall we go? All right, so good afternoon.
and thank you for giving us some time to share with you a few of our thoughts after proceedings were adjourned today. Right from the onset, let me give you a little narration of the background so far. We have been in court because a petitioner, Mr. John Dramani Mahama, has invoked the jurisdiction of the Supreme Court that, among other things, upon a proper reckoning of the December 7, 2020 presidential election results, no candidate achieved above 50%. And therefore, the declaration as made by the chair of the Electoral Commission is in breach of Article 63, Clause 3. And from the onset, he indicated in his petition that he will be calling 5 witnesses who will be adducing evidence before this court to prove that indeed nobody got 50% plus 1. On the first day for his first witness, Mr. Johnson Asiedun Ketia, you all observed how, upon cross-examination, upon various scenarios, he kept coming to the same answer, 47% for the petitioner, 51% plus for the second respondent. We were informed that he intended to put a second witness in the box who adduced further evidence that nobody crossed the 50% mark. Dr. Kwesa White was put in the box yesterday. The crux of his evidence was that he and Mr. Rojo Metonunu were deceived by the EC chair with an instruction to leave the EC premises during the collation. And upon further cross-examination, he admitted that the EC chair could not actually instruct them so to do. We have been waiting for the evidence or further witnesses who will provide evidence that nobody crossed the 50% mark. This is the government of their case. Today, we were seized, or the court was seized with an application that was filed yesterday. And I heard our colleagues who just left say that this has been there for a while. It's not true. Check the date on the application. This application was filed yesterday. This application was filed yesterday. In fact, it was filed. It was served on us yesterday, but it was filed the day before. So this claim that this application had been put in way ahead of time is not true. That's why you heard our counsel talk about 34 days after the initial application. But be that as it may, this application is aimed at giving the petitioner an opportunity to go and inspect some documents. Inspection of documents generally is allowed in litigation. But it is not a matter that you have as of right. It is at the discretion of the court. And you have to convince the court or establish something before the court for the court to grant it. You have to prove that there is some necessity for you to be given leave to inspect those documents because, among other things, it will be necessary for the fair disposal of the matter. Without it, there will not be a fair disposal of the matter. And that it may also be necessary to reduce the cost of litigation. You heard Mr. Chachuchi Kata on his feet for about an hour trying to establish the necessity for which they should be granted leave to inspect these documents. And you heard counsels on the side of the first and second respondents argue that no necessity has been demonstrated because all of those documents are already in the custody of the petitioner. And the petitioner has not demonstrated before the court that there's anything wrong with the copies that he has, and therefore asking to inspect the originals. Because you have the documents already. Indeed, some of those documents were attached by the petitioner himself to his petition, some of the witnesses as well to their witness statements. And so the principle, the legal principle of necessity for fair disposal of the matter has not been demonstrated. And there has been no argument even made about a reduction in the cost of litigation. We also noticed, principally, that as the case moves on, and particularly with this application, the petitioner is now seeking to invite the court to breach a time-tested rule in litigation that he who alleges must prove. You come to court with your own case and your burden of proof is on you. It is when you have satisfied what we call a case, you have made a case in law, that the burden of proof now shifts onto the respondents or the defendants to respond. Indeed, if by the time you are done, and for those of you who are court correspondents, you will know, if by the time you are done submitting what you think is a case, the legal threshold of making a case under the law has not been made, the respondents or the defendants have the opportunity to move a motion for no case because you have not made a case. So it is when you have moved a case and satisfied the legal threshold that the burden of proof shifts. We are observing that this is an attempt to shift the burden through the back door. Now, the court, as you observed, rose to consider the various arguments and came with a ruling. Before then, plaintiff had made an argument that if you have nothing to hide, why don't you produce the documents? Those documents are even on the internet. They have been published already. They are within the custody of the petitioner. So don't be swayed by this propaganda line that if you have nothing to hide, why are you not producing the documents? The documents have been made available. They are already in the custody of the petitioner. They are in the custody of all other political parties or candidates who took part in this election. They are in the custody of the second respondent, and they have not demonstrated any necessity for it. In the end, the court ruled, and I just want to quote what the court said through the respected Chief Justice. Said the applicant has not demonstrated the necessity that must be met, and that indeed on record they have admitted that they have the documents. No proper case has been made for this application, which we have spent a number of hours on today. And if you look at section, I think 166 of the Evidence Act, they have not raised issues of authenticity even. And therefore, it is not the 1 hour, submissions and English that would invoke the court to exercise its discretion in this matter. You must ground it in law and proof same. We are of the view that the pendulum swings back to the petitioner, who had advertised that he has 5 witnesses who will give evidence to show that nobody got 50%. We've heard the first 2. The jury is out on that one. If there are 3 other witnesses, now will be the good time for them to either submit those witnesses to adduce this evidence that shows they are supporters that they told they had won and then they came to change the story, but that will show them that indeed nobody won. Or if they are not able to put further witnesses before the court, then they would have to bring down their case, and then the respondents will also have to now move to their next line of action. We think it's generally been a good day in court for justice, and we look forward to the directions of the court on Friday.
So, Mr. Minister Designate, Mr. Kojo Nkrumah, 2 questions. The first one is that we've noticed that in court, most of the time, the petitioner's side is doing very long arguments, whereas the respondents, both you and the EC side, do very little arguments. What's accounting for this? And again, every time we've come to court when there's an adjournment, the Chief Justice will indicate what will happen next in the next sitting. This adjournment, there is no such indication. Can you give us some indication as to what we should expect at the next sitting?
I mean, obviously, you saw the bench invite lead counsels into chambers and have a set of conversations with them. We were not in chambers, we were not privy to it. It was something that obviously they did not want to advertise in open court. I am sure that that has an influence on the adjournment and the directions for Friday, but we are not in a position to say because we were not in there. We'll look forward to whatever the Honorable Court will put out on Friday. But to your first question, yes, as a matter of fact, you notice that counsel for the petitioner sometimes has about an hour. In fact, today you noticed from about 9:30 something to about 10:30 thereabout on his feet making arguments. And counsels for first respondent and second respondent are very crisp in their responses. It is because this is a court of law, not a court of public opinion. When you make an application before the court, you must satisfy what the law requires and back it with authorities that are relevant or the legal invocations that are relevant. For example, if you recall the application for leave for supplementary, counsel for the petitioner was on his feet for several minutes, but if you listen to the ruling of the court, it says that even the authority that you cited, Elistamaklu, has nothing to do with supplementary applications of this nature. And the expectation that you will give us good law to back your application did not happen. So we are not invoked. Counsels on our side, you would notice, are limiting themselves to the law and the legal requirements, are not necessarily arguing with the bench, and are speaking to matters of law. So what does the law say? That is what we are interested in arguing. So if under CI 127, under Rule 44, there's a clear provision that forms are set out and must be made available to all parties. All we need to do is to invoke that. We don't need a lot of grammar to make our case. And that's why you would have noticed that we are not spending too much time speaking English, but we're speaking law.
Being a journalist yourself, you understand how we get when we don't get the information we seek. So, follow up to his one of his questions. Do you have, and can you help us with any indication as to what would happen on Friday when the court reconvenes?
I cannot, because as I've mentioned, we were not in chambers with the judges. We are expecting, and if you look at the natural flow of this case, we're expecting the petitioner, because the law says he who alleges must prove. The petitioner has told us that he has 5 witnesses who will prove, among other things, that nobody got 50% and that we should go for a runoff. Not so. The petitioner has put 2 witnesses in the box who have been cross-examined. We are expecting that the petitioner ordinarily will call the other 3. The petitioner today brought an application which was filed just in the last 48 hours, which application is what has consumed our time. And our expectation is that the petitioner will either continue with the 3 other witnesses or inform the court that they intend to bring down their case at this point for the respondents to now also move whatever submissions that they may have. Intervening in these 2 is this new application that they brought, the chambers hearing, and the direction that we should come back on Friday. So we'll wait on Friday and hear what the court has to say.
Mr. Minister Designate, the petitioner spokespersons said that they don't have copies or carbon copies of this Form 13. May I know if you have one and why they don't have one?
So you should listen clearly to the court. You see, sometimes when we come to court, it's not what counsel on our side says or what counsel on the other side says, because lawyers and witnesses can say so many things. In the end, it is what the court finds. And if you heard the court clearly, the court started off by invoking CI 127 Rule 44, where copies are made available, and proceeds to say that the court is clear in its mind that all of those documents are available to the petitioner, and I dare even say by extension to all other parties who participated in this election in accordance with the law. That's been the very clear finding of the court and ruling accordingly.
Mr. Nkrumah, your side has always held from the very beginning that...
I'm sorry, I can't hear you very well.
I'm saying your side has held from the very beginning that the petitioner has no case. You have told us that they've gone through their witnesses, they finished with 2 of their witnesses who provided yes. 2 witness statements. You also cited the High Court procedures of how when applicants make a case and they send witnesses through and they are done, what happens next? Will your side file a submission of no case on Friday or going forward?
Well, they have not, in our understanding, completed making their case. They have only called 2 out of 5 witnesses. The first one is the one who came in ostensibly to suggest that nobody got 50%. But you saw this witness always calculating and getting 47.51. The second one, who you thought was also coming to provide evidence that nobody got 50%, came in only to say that he heard through Rojo Metilnuno that they were instructed to leave, and later admitted that nobody had power to instruct them to leave. As to how that accounts for nobody won 50%, I'm not sure. They have 3 other witnesses that they have informed the court they want to call. So it is at the end of the making of what is ostensibly their case that respondents will take the next line of action.
My right honorable, primarily the court asked...
I'm sorry, I'm struggling to hear you, sir.
My right honorable, good afternoon. Primarily the court asked for more details from the plaintiff, the complainant, that the case was adjourned to the 27th. Now, have the details, all the details been supplied? And is that the reason why there's an adjournment to Friday for a decision? And if all the details have not been supplied, is there a reason for an infraction for continuity at all in this case?
As I've mentioned, I cannot guess the purpose for the court's order of adjournment. We are in the hands of the court. We'll come back on Friday and hear whatever further directions they may have. I want to thank you. After one more question, and then I would invite my colleague to wrap up in 3.
Honorable, this morning, the lead counsel for the petitioner asked a question in court that if the EC's interest is in transparency, then why is this so difficult for them? Indeed, you have on several occasions spoken about the public opinion that the lead counsel for the petitioner appears to be pandering towards public opinion. But public opinion is also very important for clarity. If indeed there is nothing to hide, why are we using the law to prevent the EC from coming up to give sunshine to these matters?
Well, so the EC has already provided sunshine to these matters at the 38,000 polling stations in the country, at the 275 constituency collation centers, at the 16 regional collation centers, and then at the National Collation Center, and has made all those relevant documents in accordance with Rule 44 of CI 127 available to all parties. When you come to court beyond that and you want to invoke the discretionary jurisdiction of the Supreme Court to inspect the so-called originals, there is some legal standard you must meet. The legal standard is not the propaganda question of if you have nothing to hide, why don't you show me? It's not in the law. The law says that you have to show what we call necessity. Necessity to fairly dispose of the matter. And that if it is not done, the matter cannot be fairly disposed of. That you must show that there is necessity to reduce the cost of litigation. As you heard counsel for the petitioner argue, he was not able to satisfy that threshold. So, my dear brother, don't fall for the propaganda argument they make on the side. There's a legal threshold. As you hear them make the argument, for example, like I cited in the earlier one for application for supplementary, there's a legal threshold. You don't fail that one, cite wrong cases, cite wrong authority, and then now throw in a propaganda question that asks them that if they have nothing to hide, why? This is a court of law. So if the court and the law imposes a legal threshold, that he who alleges must prove that you satisfy the concept of necessity. You recall in the case of interrogatories, it's not a propaganda argument, it's that why are they not allowing us to ask our question? Why are they not? No. The law says that the interrogatories must be relevant to the issues. So if you ask questions that are not relevant to the issue, you will not be allowed. You don't get to go around making the argument that why are they not allowing us to ask questions? No, the questions must meet the legal threshold. Thank you very much. My colleague would do the tree translation for us.
Abusanfo yabeda mo ase ene eye eda etoso enkono a yehia wo eye court dem ha nene ne course ye nyina ye nim eye petitioner bibia no mo so mo onyina so omo evidence omo onyina so na eye opinion schedule nkatia a ono ebedi adanse eye ma former president Mahama na no obo betena adakam ye toto na no ye hu se ne nsem ni nyina no ensisi so enron so eye opinion pesa white enso ebetena adakam eno so ye nyina ye hu ni ye ko ye se ne nsem ni nyina no atonsuom enti adansidi a omuni enti ene ye de krata ba be to court anim se eye krata omo ankasa omo wo bidada sanse emra no eye CI 127 no ehye isi keten se woto aba no polling station wie na se ye kenkan ye hwegu ho na ye de ni nyina no egu krata so a eye parties obibio take part bia na musini no eho behia se obenya krata ni bi ebiem se eba constituency nso a emra ne hyeketin se krata na yabunkunta aguso ne ya kire obia ema onya ye no eno nso emra ne hye isi ketin se obia party bia na musini no ebenya eno nso copy sa ena oba region so a etie ena oba national so a etie eye petitioner eba no wankasa nkratai onya bi onka ba bia sada awo ne krata o de aba to court mu enne omo say 275 constituencies no yemfa ho krata nyina ma omo isi emfa ma omo Ebiem all the 16 regions no so no easy emfa ho nkrata nyina ma wo mo ansa na ye ba national so yemfa ho nkrata nyina ema wo mo na abusuafo nea ehu hia ye pa ne se sankrata nyina so omu obi dada etienei se obehwa kasatintin wo hoi entoponko twene so animu da ho a ye monche mu asempa wo hoi etia etinya kasatintin donhwere no ene nsem a obeka asabia ye ntwanchia no ena eno beka se owo asem etiene wo hwe easy lawyer na wo hwe eye president Nana Akufo-Addo lawyer nsem o mo kan na gina mra no so omo se sankrata nyina omo obi ina biem nso no omo hu hia omo ntimi enda na di se hu be hia se o se wei no ye de ma omo eho ena Supreme Court ekọ ena osabaye mpanifo baye omu nyina mpanifo nso ni nyina adwen ekọ benkrom ena omu nyina se eye saa ensem yi a mo se yemfama mo nam pese mo hwe nkrata mu yi ne edikan mo wo saa nkrata ni bi dada ne toso mienu ehu hia no mo ntimi enkyereye ne toso miensa mo nsan enka o mo petition ni mo se nkrata no mo nsan ka eti se wo ko eye yemramu Evidence Act na eye section 166 eda na di pefe secretary bia ye be mawo ebie se ne potoka se me kan carbonized copy no secretary ne de mawa ni original no ene ni nyina no eye pe a court agitum se ya dance ye enu nti no court mpanimfo nsun ebo eye ensem no enyina eguye abusia mamema ne nda na di se ekamya kwa se eye petitioners eye former president Mahama onia dance ye inti court dem ho no person odiniti ebo bodan mu no pa dance ye enti onia dance ye inti no na anu ye busa se na mu ankasa mu ye mu collation no eye former president Mahama onya say opani ese gun ketia say my lord I have not brought that figure to court chese sankuntabuo no manfa ma court na wan so president awugina manu so onya say enu so onim na nanado de nso onya say enu so onim na total no so eye say enu so onim eti enne asem a ekosi ye no court abo ni nyina egu na asem ba ko esi ya na eni enyan na o se ka ho asem asem bi si no pani chachu asem o kan ni say eye judge pani pa no na asem o kan no eye completely irrelevant questions obusa no wey sa kasa twitwe ahantan kasa asa ye pese ye ka na efu justice for no ebo no ade a o se kasetia very unfortunate se pani lawyer pani pa wonim de na wutimi ene judge pani akasa asem ni firi wa no kraba very unprofessional language o se ye ka enti wey ene enema ene ekoso ewo Supreme Court a wo se ye ma munyina mu dadi abusuafo ebedamase na ansa na no mesre sanse ye ne mpanifo ene wa ha a lawyer for mutamachi ene chairman makmenu emu wa ha obapa Joyce enso wa ha lawyer Joyce Boatin enso e wa ha sei ena Hajia Fati Abubakar onso lawyer nipa deputy director office of the president lawyer Nana Adjoa Adobia Santi enso ewo ya ha sei ansana eye Evans Nimako ya lawyer for mpanifo mu di animu aye lawyer Kotampao lawyer Frank Davis lawyer Adodapa lawyer Kwaku Asifi lawyer Yaw Opon lawyer Shelaminka Premo lawyer Victoria Beth lawyer Ochiri Ejekum ena lawyer Dr. Ernest Ousdapa ena president Tankasa Council mua eye ko asuman enso eka ho bi ena enne yede ensempan bram nyame yadoma efiada yebehia nyame nhyamu.
Thank you very much. And those were the two press conferences which are held on a daily basis by the Petition.